David DeMoro.
Hi, folks. David DeMore. I'm with the Council of State Governments Justice Center, where I am a senior advisor, and with the team working here in Vermont.
Thank you. Sarah Friedman.
Hi, everyone. Sarah Friedman, also with the Council of State Governments Justice Center, and looking forward to talking with you throughout the meeting.
Thank you. Next one is a phone number. It doesn't show the whole number. It's 802-3-something-something-something-32. Who's that?
Chief, it's John Campbell.
Oh, John, how are you, John? Go ahead, introduce yourself, please.
Thanks. John Campbell, Executive Director of the State's Attorneys and Sheriffs.
Thanks. Alan Cormier. Alan, you're muted, Alan. There you go.
Sorry. Good morning, Al Cormier, Chief of Operations for the Vermont Department of Corrections.
Thank you. Alice Emmons.
Alice Emmons, Chair, Representative Alice Emmons from Springfield, Chair of House Corrections and Institutions Committee.
Thank you. Alice Nitka. Senator, you're muted.
Alice Nitka, Senator from the Windsor District. I'm on the Judiciary Committee.
Thank you. Alison Hart.
Good morning, everyone. Alison Hart, AHS Director of Policy and Program Integration.
Angie Gunter.
Good morning, everyone. Angie Gunter with the Council of State Governments Justice Center.
Ashley Messiah. And if I mispronounce your name, correct me, will you please? I'm sorry if I do, but you need to correct me. Go ahead, Ashley.
Ashley Messier, Executive Director, Women's Justice and Freedom Initiative.
Thank you. Dale Crook.
Yes, hi, Dale Crook, Director of Field Services for the Vermont Department of Corrections.
David Scher.
Good morning, David Scher, Assistant Attorney General, representing the Attorney General's Office.
Derek Miodownik. Sorry, Derek.
Good morning, Derek Miodownik, Community and Restorative Justice Executive with the Vermont Department of Corrections.
Thank you, Derek. Dr. Eaton.
Eitan Nasreddin Longo. I'm the chair of the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel.
Thank you, Dr. Eitan. Elizabeth Morris.
Good morning. I'm Elizabeth Morris. I'm the Juvenile Justice Coordinator at DCF FSD.
Falco Schilling.
Hi, I'm Falco Schilling, the Advocacy Director with the ACLU of Vermont, here on behalf of James Naflio.
Gary Marvell. Gary, you there? All right. Judge Grierson, Brian Grierson.
Good morning, Brian Grierson, Chief Superior Judge.
James Pepper.
Good morning, James Pepper, representing the Department of State's Attorneys and Sheriffs.
Jim Baker.
Good morning, Jim Baker, the Interim Commissioner of Corrections.
Judy Henkin.
Good morning, this is Judy Henkin, and I'm the Deputy Commissioner of Corrections.
Julie Scribner. Julie, you're muted. Karen Gannett.
Hi, everyone. Karen Gannett, Crime Research Group, Vermont Statistical Analysis Center.
Karen Tronsgaard Scott.
Good morning, everyone. I'm Karen Tronsgaard Scott, Executive Director of the Vermont Network Against Domestic and Sexual Violence.
Kelly Doherty. Kelly, you're muted. Kendall Smith. Good morning, everyone. Kendall Smith, Governor Scott's Director of Policy and Legislative Affairs. Kim Bushy.
Good morning, everyone. Kim Shink, Program Services Director for the Department of Corrections.
Loretta Sacchi.
Good morning, everyone. My name is Loretta Sacchi, and I'm with the Council of State Governments Justice Center. Thank you.
Madeline Dardo.
Hi, folks. Madeline Dardo, I'm a analyst at the CSG Justice Center.
Mary Jane Ainsworth.
Good morning, everyone. Mary Jane Ainsworth. I'm the Executive Director of the Parole Board.
Monica Weaver. Monica, you're muted. You know, I make this point. It looks to me as though Monica Weaver may be on, but unable to get through. Sam, give folks your email address again so they can contact you about trying to clear up the connection problem they're having.
That's a great idea, Chief. What I'm going to do is drop my email in the chat bar, and then it's just samuel.griffith, that's GRIFFITH @vermont.gov.
Thank you, Sam. Morning Fox.
Good morning. This is Morning Fox, Deputy Commissioner, Department of Mental Health.
Matt Valerio.
Morning, Chief, and everyone. Matt Valerio, Vermont Defender General.
Thanks. Pat Gable.
Patricia Gable, State Court Administrator.
Representative Maxine Grad.
Good morning, Representative Maxine Grad of Moortown, and I chair the House Judiciary Committee. Thank you.
Sean Brown.
Good morning. This is Sean Brown, Commissioner for the Vermont Department for Children and Families.
Susanna Davis.
Hi, this is Susanna Davis, Racial Equity Director for the state.
Thank you. That's everyone on my list. Did I miss anyone? Have I missed anyone? Yep. Please, Monica, are you there? Okay, if you're having trouble connecting, if apparently we cannot hear you, which may be the case, Sam Griffith has put his, I see Gary Marvell says he's got no audio. Sam Griffith has put his contact information in the chat box, so please connect with Sam. He's a terrific guy, and he's been doing a tremendous job on this project and everything else that he's been involved in. So I'm sure he can help you out. All right. Thank you all again for tuning in here this morning. Any questions about process before we get started? Excuse me. Okay, so I'll turn to Sarah Friedman. Sarah's going to make the first presentation. Sarah?
Thanks so much, Chief. And David is sharing the PowerPoint for us because I'm just doing a few slides before he launches in. So thank you all for joining us for this first meeting in 2021 of the Justice Reinvestment 2 Working Group. Really pleased to be here speaking with you all. As folks should remember, because this is the fourth one of these you've attended since September 2020. The working group does have a report due to the legislature as per Act 148 on Friday, January 15th. So David, we can go to the next slide. We have just two reminder slides that we have to put in every presentation, quite honestly, about who the Council of State Governments Justice Center is. I hope that everyone here knows us pretty well by now, that we're a national, nonpartisan, nonprofit membership association that works to help states improve their criminal justice systems. And David, you can move forward. And you all know that this is part of the Justice Reinvestment Initiative, a data-driven approach to improve public safety, reduce corrections, reduce corrections and criminal justice spending, and reinvest savings and strategies that can decrease crime and reduce recidivism. And of course, this is Vermont's second bite at the Justice Reinvestment apple, hence we're in Justice Reinvestment 2 working group. Next slide, please. So as the chief said, and as you all know by looking at this 8:30 to 1 p.m. meeting in your calendars, we have quite a lot of material to cover during this meeting, leading up to the report and making sure you all hear implementation updates, another part of the working group's duties now that Act 148 and Justice Reinvestment policies have been passed. So for the presentation part of the meeting today, we have 5 sections. A quick intro that I'm going to give, talking through policy options for mental health and substance use disorder, which will be David. We'll have a break, and then we'll go into the probation earned credit conversation, continuing conversations from the October and November meeting. And then we'll also be talking about those reinvestment recommendations from the November meeting that you all have seen before. And then we also want to talk through implementation and sustainability with you. Now that's just the CSG's presentation part. You guys are not off the hook after that. There'll be another break, and then we'll hear from Dr. Eitan Nesrat-Longo about the work that RDAP has been putting into Section 19 of Act 148, and we'll hear from Monica Weaver at DOC, hoping and praying that she gets her audio up and running, and Mary Jane Ainsworth at the Parole Board about all the implementation work that they've been doing leading up to January 1st, 2021 effective dates for Act 148. So that is what's in store for you all. You also have an agenda, and I know we sent out a huge number of meeting materials for your perusal. I will refer to those when needed as we go throughout the presentation, and some of them are more background information just for folks to have on hand in case you need that. All right, we're ready for the next slide. So this is the timeline that you all have seen for the last couple of meetings. You know that this is the 4th meeting. We're kind of going from a timeline where Act 148 was enacted in July 13th through January 15th, this Friday when your report is due, just looking at all the work that you all have done thus far. You can move to the next slide. So today I actually just went over this. This is an overview. We've been having these slides telling you everything that you all will be doing in these meetings. And I did that on the title slide, so we actually can skip through this one as well. So this is just a reminder about your report that's due this Friday. So in the September meeting for the report, you prioritized 4 specific statutory duties from Act 148. That was to study earned time for people on probation and explore other related policy options, and then 3 other statutory tasks which really all go hand in hand with each other. So identifying ways to increase DOC and community provider risk and needs assessment information sharing to help inform plea agreement, sentencing, and revocation decisions, determine screening, assessment, case planning, and care coordination gaps for people with complex mental health and substance use issues, and identify new or existing tools to identify risk factors that can be targeted with treatment and services. So these are the things that this presentation is focused on. So what we're doing with this PowerPoint, though, just so everyone, oh, sorry, David, I'm not quite there yet. What we're doing with this PowerPoint, just to be really clear, is that this presentation is a rough draft of that report that's due January 15th. So you'll see a lot of background slides from past presentations, because those we want to be in the report to kind of give a holistic view of all the work that you all have done since September. David and I, when we're presenting, are going to be mostly breezing through these background slides, so it's not too redundant, but they're there to give you a full picture of what we're recommending go into this report due Friday. Also, I just wanted to really focus everyone that throughout this meeting, we're going to be looking for guidance from working group members on what recommendations you all want to make to the legislature. We'll begin to tackle how to make those recommendations once David has presented policy options on substance use and mental health. As per statute, These report recommendations are really focused on the probation credit and then the coordinated information sharing around mental health and substance use for people in the criminal justice system. Just to be really clear, that's what Act 148 requires you all make recommendations on in the January 15th report. After we tackle these topics, which we're going first, you'll hear from Madeline, also CSG team member, present other considerations around reinvestments and sustainability. The working group doesn't technically need to make explicit recommendations in the report on these, but the CSG team wants to provide you guidance around these and hear from you about your feedback on these topics as we figure out our best path forward for future working group and implementation sustainability. All right, David, now we're ready for you.
Good morning,
You
everybody.
might be muted, David. Oh, there you go.
Yeah, it took me a moment to unmute there, but good morning. It's nice to see all of you again, even if from a distance, and look forward to spending a little bit of time here going through our recommendations in terms of options related to mental health and substance use disorder and ways to improve the systemic responses to those issues that clients have. As Sarah mentioned, a number of the slides I'll talk about you have seen. Some of these are background, and I will go through them fairly quickly. Once again, Act 148 directs the Agency of Human Services to work with the Justice Center staff to report current mental health and substance use assessments, case planning, and information sharing practices. And there are a variety of important stakeholders, of course, that we need to keep in mind when we're talking about these issues. The Department of Corrections, of course, Department of Mental Health, Department of Health, Department of Children and Families, and of course, the Parole Board as well. Vermont already has most assessment and screening processes in place, as we've talked about before, when we're looking at the issue of how to best identify mental health and substance use needs as people are moving through the criminal justice system. And as I've also said before, but really need to say again, Vermont should be very proud of this. While there are a couple of, if you will, gaps that we think need to be fixed, overall, the number of places where people get assessment, the fact that so many folks, whether it's detention, sentence, furlough, parole, or probation, are getting at least some, and in some cases, all of the different types of necessary screenings or assessments, puts Vermont very much at the front of the pack in terms of how this is responded to by the system for folks who are in the criminal justice system. Now, Vermont does have treatment case planning policies in place, but there are, as we've talked about before, still some inconsistencies in how people are connected to community-based mental health and substance use treatment services. There are challenges that have been going on related to sharing relevant mental health and substance use information, as well as the coordination of care between the Department of Correction and the community-based providers, which can negatively impact the overall case planning and then ultimately the treatment and programming referrals. Now, it's not, there's an inconsistency, meaning some very good things going on and then some things missing across the state, depending on where you look. Some of the supervision offices have very strong relationships with the local services, and they leverage those connections to help the clients connect with the available services. And I saw this when I was in Vermont, but it's not consistent across the state. So there are geographic variations in care coordination. And for folks with co-occurring disorders that are on medication-assisted treatment, there can be a lack of coordination for mental health treatment across the various providers and supervision agencies, supervision agents. Assessment and screening results are not consistently shared between DOC, and by that we mean the healthcare contractor, facility reentry caseworkers, supervision officers, and the community-based providers to inform case management and care coordination. And what we have been talking about consistently, of course, is the need for consistent, collaborative, coordinated case planning throughout the state, not just in certain parts of the state. Mental health and substance use information sharing between DOC, community-based providers, and the parole board is again inconsistent across the state. Current information sharing between supervision officers and community providers tends to be based on the relationships that have been developed rather than established processes or policies. And so therefore, it tends to vary widely across the state. At the moment, AHS does not have an umbrella information sharing policy, though they are indeed working on that, to be clear, that governs how its departments share information to support folks with mental health and substance use needs that are in the criminal justice system, who are at this point almost routinely in need of services by more than one, and frankly, more than two of the departments or of the agencies that work within AHS. For people who are sentenced straight to probation, there is less mental health and substance use assessment and screening information available to inform supervision conditions than there is for folks that are transferring transferring to furlough or parole. So Vermont does face a number of challenges in terms of improving information sharing. There are real and perceived limitations related to federal privacy laws and regulations, including HIPAA and 42 CFR Part 2. Please note I said real and perceived. There are some real issues that systems have to figure out how to work with in terms of making sure that they have appropriate information sharing and are not doing the wrong thing. We also typically find that folks have perceptions of limitations that actually, when you study those particular regulations, they aren't there. And so that's one of the reasons why it's important for a working group to be paying attention to this and to be working together to determine what can and cannot be done, what can and cannot be shared appropriately. There's inconsistent knowledge across the DOC staff, parole board, and other criminal justice stakeholders regarding evidence-based practices for serving people with substance use or mental health needs. And again, I saw a variety of differences as I was across the state and as I looked at and sat in on a variety of different parole board meetings. Some folks have tremendous amounts of knowledge, others less so. That's not surprising, but it does become problematic when you don't have that consistent base level of knowledge across all of the different folks that are involved. There's inconsistent knowledge also among community-based providers about serving people in the criminal justice system. Although in talking with those providers, they are, for the most part, very interested in knowing more and in collaborating in a better way with those folks, those other systems that the folks that are in the criminal justice system are working within or are receiving services from. So lack of resources to address geographic disparities in mental health and substance use disorder health services, and a lack of resources to increase information sharing to inform supervision conditions pre-sentencing. So the working group prioritized 3 interrelated areas of study regarding mental health and substance use for the report to the legislature. 1, determine screening, assessment, case planning, and care coordination gaps for people with complex mental health and substance use issues in the criminal justice system and recommend system improvements. 2, to identify ways to increase DOC and community provider risk assessment information sharing to help inform plea agreement, sentencing, and revocation decisions. And 3, identifying new or existing tools to identify risk factors that can be targeted with treatment and with services. Working group can consider several options, and I'm going to go through 4 options. I want to just make a point here. The language that's used and that we use are options or policy options, because that is the nature of the work that we do. In this particular case, we're not suggesting that you need to choose between options 1 and 4. We're suggesting that these 4 options should be moved forward, as opposed to just one or the other. Now, you may choose to not move them all 4, but I don't want you to hear us saying that you need to choose one of the 4. In fact, it would be our view that all 4 of these are important to happen. What you see also next to the option is whether or not, in our view, the implementation of those need to be done administratively or whether they need to be done legislatively. Option 1, we're suggesting, can be done administratively, and we've recommended that AHS convene representatives from each relevant department in the agency to develop and implement changes to policy and procedure that address the barriers to information sharing and care coordination for supporting people in the criminal justice system with mental health and substance use needs. We suggest that the AH group could collaboratively modify agency policy and procedure in order to adjust provider contracts to supply and provide structured information sharing practices to standardize AHS mental health and substance use needs information sharing between DOC and community providers, including the sharing of assessment results, to adopt a collaborative coordinated case planning model, and to identify opportunities for ongoing mental health, substance use, and criminal justice cross-training. I am pleased to say that, in fact, AHS has already beginning a lot of this work. And we, in a recent meeting with the department heads and with Secretary Smith, heard from them very clearly and strongly that they are indeed interested in doing this work and in developing improved collaboration and coordination between the departments and the agencies within AHS. Option 2 that we're suggesting also can be done administratively, which is recommending that the Department of Correction use a validated mental health screening tool for people sentenced directly to misdemeanor probation. And again, as I said, there are so many areas where this is happening and where screening and assessment is happening well. There are only a couple of areas where there is room for improvement or that there's a gap, if you will, and this is one of those. And one of the things that I also want to mention as you look at option 1, 2, and 4, the way that we talk about this is in an overarching, if you will, meta way. The department, as it moves forward, or AHS as it moves forward, needs to figure out the best ways to do that. And you never want to get into a situation where you lay out the specific, because things can change. So, for example, in some states, they've done things like they've said, you will use tool A. We really don't suggest that. We really suggest that what's important is that the type of tool be used, in this case, a validated mental health screening tool, but that the folks that are involved in doing the work make the determinations about the best tool or tools to use, because we're learning new things every year about tools. And when you start putting things in writing and saying it must be this one or that one, in many cases within a year or two, we have new information that suggests that we should be adding something, using a different tool, et cetera. So we want to be careful and make sure that folks that are putting these things in place have the room to make the determinations and choose the best kinds of tools available. Option 3, we're suggesting is more of a legislative option, which is recommending that the legislature require the Department of Correction to develop a brief report that will be provided to judges before sentencing in order to inform condition setting for all felony probation cases. The report should include risk and need assessment results, mental health and substance use disorder screening results, and criminal history. And I want to make it very clear that we are not recommending something that would be like a PSI, which takes many weeks, nor are we recommending something that would create a big delay in terms of decisions that need to be made. A lot of this information already exists or is already gathered. And again, DOC needs the freedom to be able to determine what's the best way for us to do this in a way that is efficient, that does not take a lot of time. And there are a number of things that will need to be worked out in terms of who gets that information and when, et cetera. And so it's important, again, that the department in this case have the ability to make those determinations and figure out the best ways to do that. But the overarching issue is courts need to have relevant information when they are making decisions about, particularly about stipulations for people who are going to be on probation. I saw too many situations where things that needed to happen for a client were not happening. They were not getting into treatment or being told to be assessed for programming. And in other cases, I saw things being handed down that, one example being anger management, which is not necessarily relevant to that individual, but you sort of see some things get routinely handed down without there being some prior assessment to determine whether that's needed. And so what we're suggesting is that for everyone's betterment, if you will, for better public safety, because you're having people, you're giving people the correct stipulations, better success for the individual who getting what they need in particular related to their issues, better for supervisors because they have their folks now getting what it is that's necessary, and they're not, if you will, in a box about seeing things that are needed and wondering how to get those things in place, and better for the individual in particular because of the issue of hopefully, as we look at this issue of the constant cycling of people back into the system, better for folks in terms of stopping that second, third, fourth, fifth time that they might be coming through the system, whether that is to furlough or to incarceration or in whatever way that might be. And then the fourth option is the only one that I think we probably have not previously discussed with you over time, and we're defining this one as a strategic option. And we added this option in really out of ongoing discussion with Commissioner Baker and with other folks. And as we think about the population that DOC has, we know from all of the information that we've gathered and that we've shared with you, it's a complex group of individuals with significant mental health and substance use needs. And when you look at the numbers of people that are failing on supervision that have those needs, that's a significant issue. When you look at the needs for better coordination and liaison between the Department of Corrections supervisors and community providers, becomes a significant issue. So we're recommending that DOC explore hiring a licensed clinician to be placed in each of the local offices in order to administer the mental health and substance use screenings and assessments and to liaise with the community-based treatment providers. I want to be very clear, two things. One, we're not recommending that these people provide treatment. That's the job of the treatment providers. What we want to do is we want to raise the mental health and substance use IQ of all of the supervision offices. Officers have inconsistent knowledge about this. That is not their fault. It is also not the job they were hired to do. Nevertheless, the reality is that they are case managing, and overwhelmingly, they are case managing people with mental health and substance use needs. And so in order to help improve their knowledge, in order to help improve the relationship between the offices and the community-based treatment providers, and in order to help develop a better wraparound process, because it's not just the community-based mental health and substance use treatment providers, it also has to do with housing. It also has to do with a variety of other areas. And so we are suggesting or recommending that this fourth option also be an option that the working group recommends, and that each department and each office end up having a licensed clinician in it. Also, there's been some discussion going back and forth where in some cases they might do a pilot that relates to hiring clinicians, DOC hiring. In some other cases, designated agencies that are very strong in a particular area and have the capacity, they might have somebody that they can embed. Again, this is something that I think DOC and AHS in general needs the ability to figure out the best way or ways to do this, to accomplish this. But the end goal, again, is important, which is that we increase the behavioral health or the mental health and substance use knowledge of each supervision office across the state. So those are our four policy options that we are recommending and hoping that the working group will move forward. And with that, I will turn it over to either Sarah or the Chief Justice.
So David, what I would recommend is if you could stop screen sharing so everyone could see each other. And then I just want to flag for everyone that in your meeting materials, you all have a copy of this entire PowerPoint, but you also have a document that's summary of policy options and considerations for the January 11th, 2021 Justice Reinvestment Working Group meeting. And if you all open that attachment, which I think came to you Friday and also this morning, so whichever is the easiest place to get it, this is just the policy option slides in a PDF format. So while you all are talking about it, you can refer back to them kind of on your personal computers so that you all can see each other while discussing these policy options, but still, you know, refer back to how they are written. So Chief, I look to you, but what we're hoping now is that you all can discuss the policy options and what the working group wants to move forward in the January 15th report. And if this also might be an opportunity to discuss how you all want to come to consensus or make those recommendations to go into the January 15th report by, you know, essentially is there a mechanism, or by what mechanism do you guys want to give us directions as a working group?
Thank you. Sorry about that. Thank you very much, Pat. We could follow Robert's rules and take these one at a time, and I could invite a motion in a second, and we could discuss and then have an up or down vote on each one of these. I'm not sure that that's the way I would prefer to do it, at least initially. I think we need to have a little bit of an open-ended discussion about how we're going to move forward. I do remember David saying that these are all options for recommendations to be included in the report. From CSG's point of view, they would include all 4 in the report, but we're not. Our working group is not bound to, to move to that place. You can include one or more than one in the report itself. So if folks want to have some discussion about how to proceed, one of the ways we could talk about these options, we could take, I think there are 2 that are written in the passive voice, I believe. One is option number 4 is to explore hiring, DOC to explore hiring. There's no mandate required in that, but it's up to explore it. Option 1 is for AHS to convene representatives in a way that's not as hard-edged as what I would think of as a mandatory sort of language, because you see that in option 2. Option 2 is that the DOC use a validated mental health, and that's a more of a mandatory requirement.
Chief Justice, forgive me for breaking in, but unfortunately, you're breaking up again. I'm not sure if people were able to understand what you were suggesting.
Yeah, and when you don't speak into the laptop, Chief, it's harder for it to pick up the audio.
Well, I've got a headset on.
Oh, well, maybe there's something with the headset.
There must be something with the headset.
I think that the headset sounds to be working. I think the closer that you lean into the computer, it starts to cut off. So,
I'll have to see if I can focus from this distance.
It's a balancing act. Yes.
Yeah. Thank you, Sam. So anyway, what I was saying was, if you look at the language of the 4 options, 2 of them are in the passive voice. It's what I would say. Others might think about it differently, but option 4, as an example, says we would recommend that DOC explore hiring. That's not really mandatory language, except to undertake an exploration. Option number 1 is that we would recommend AHS convene representatives. Again, that's not as obligatory as you might find with option 2. Option 2 is that DOC use a validated screening, and option 3 is that the legislature require DOC. So one of the thoughts I had about this was that we try to see if we can come to an agreement about option 4 and option 1 before we get to the mandatory language that's contained in 2 and 3. But we could approach it differently. Do people have thoughts about this? If you've heard me, I hope. Yes, please go ahead.
I guess I would say what I heard David say was option 1 is pretty much already being pursued, and it sounds like they're supported by the secretary. So I think recommend convening is is appropriate. And I think it's reassuring to know that they are convening. So, and then I appreciate your observations about the language. Explore hiring. I would just want to hear more from DOC and, you know, the affected entity, but I feel like that also makes sense.
Jay, could I take your comments as a motion that the group adopt recommendation number, option number 1? Can I take your comments as a motion for option 1 to include
Yes,
it in the
please.
report? Yes. Is there a second to that motion?
I'll second it.
Okay.
Dick Sears.
Thank you, Senator. How about some discussion now? And then I'm going to call for a vote. And if anybody objects to this process, you need to speak up right now. Please. Any discussion? How about naysayers? People who don't think it's a good idea that the option number 1 as a recommendation go into the report that is being generated this Friday. Anyone against that? Anyone against that? Okay, so I'm going to call for voices in opposition. If no voices in opposition, I'm going to declare it adopted. Any voices in opposition to option number 1 going into the report? Please speak up. There are 42 people on this call. If you're muted and you're having trouble connecting, you need to let Sam Griffith know, or actually put something in the chat box.
Yeah, so we were automatically muted, Chief, for some reason.
Well, there you go, Pat.
That may be more manipulative process than you.
It wasn't me, I guarantee you that. Yeah, please.
Sorry, I see a chat message from Karen Tronscott Scott. Can we get the proposal into the chat? Karen, I'm not quite sure what you're asking for, so I'm just wondering
how yeah, I'm sorry, Sarah. I think she wants the language of the option. She doesn't have the option in front of her. Option number 1. I do, but I
No, excuse me, Chief. I'm sorry. I do have the options in front of me. My confusion sits with Jay's language around. I understood that the option 1 reflects what is already actually happening. When we get down to the other options, I'm confused about that proposal. I'm sorry that I might have missed something. But
no, that's all right, Karen. I think what Jay was doing was parroting what David Demora had said. David, do you want to clarify that? You're muted, David.
Forgive me, but I'm actually not quite sure.
I think what Jay was saying was that it sounds as though this is already in place and being used, that it's something that's being done.
For option 1, the AHS has indeed begun these discussions. I can't say that every specific sub-bullet is in play, but AHS is clearly committed to working working between the agencies in a very collaborative manner, have all the key people involved, and the Secretary in a meeting last week was very clear that he supported that. And Alison, if I'm in any way misspeaking, please correct me.
All right.
Sorry, David, I just wanted to say you're completely accurate in saying that. That was the Secretary's, he's very committed to this.
Is that a negative comment to adopting it, Alison?
Oh, no, no.
I'm just trying to clarify, that's all.
No, sorry. I was just trying to support David's comment that the Secretary is very committed to this.
No, I got that. I just wanted to make sure we were clear about whether you were speaking against adopting option 1 as a recommendation in the report going out Friday. You're not doing that, correct?
No.
Okay. Any negative comments about adopting option 1 as a recommendation in the report Friday?
I'd like to add something.
Chief, yeah.
I don't know.
Just speak up. I think you're going to have to just speak up.
Okay.
Please.
I note in the group of the relevant departments that are coordinating here that there's nobody particularly to represent the interests of the individuals being assessed, basically the inmates or defendants, and that the Defender General's Prisoners' Rights Office should be part of the group.
Well, that's you.
I know.
Well, you're here. You got to say it. If you don't like it, say it.
I did.
You don't like it. Is that your
No,
point?
no, no. I didn't say I don't like it. I'm suggesting that we amend the first dot to include the Defender General's Office, Prisoners' Rights Office, as part of the relevant departments.
So you're going to have to be express about the language. Where are you, Matt, exactly in under option number 1? Are you in one of the bullet points?
Yeah, first bullet point.
So you're saying the words relevant departments include Defender General's Office? Is that what you're saying?
It should, yes.
Okay. That's a friendly amendment. Who made the motion? I forgot.
I made the motion. I don't accept the amendment. To my mind, this is all about care. And each of the agencies involved in AHS, I think the whole point of this is to be able to provide appropriate care. I don't believe that this is a legal issue or a justice issue. While this whole thing is a justice exercise, I think that the point, to my mind, of this provision is appropriate patient care. And there is not sufficient coordination or communication within AHS and the various entities that touch the lives of these people. They don't get, appropriate care because of this failure to coordinate. And I don't think we need an entity in there that's going to be objecting to appropriate care when it may serve the ends of a particular litigation.
Okay, thank you, Jay. But my recollection of the rules, and I haven't looked at them in a long time, but is that if the mover of the motion rejects the amendment, then we go forward with the motion as originally cast. Anyone have a problem with that for moving forward that way? That's the way we're going to do it. I would read that Matt Valerio's position is in opposition to the motion. Then, if you want to clarify that, Matt, please go ahead.
Well, by statute, the Defender General's Office is supposed to advocate for the issues involving conditions of confinement, and probably a third of what we do is advocate for treatment, and what our defenders do routinely, particularly the Prisoners' Rights Offices, coordinate treatment issues. So I think that I don't see this as being a litigation. I don't even know where that came from, to be honest. That's a bit of a stretch. I don't see.
I would say your attorneys and not caregivers.
Our attorneys are responsible for advocating for treatment conditions and treatment issues for individuals under the custody of Commissioner of Corrections routinely. It's probably a third of what they do without litigation.
Representative Emmons. I'm sorry. Alice Emmons, you have your hand up.
I do. It was a little bit before Matt Valerio's question. This option 1, I just want to say 2 things. One, I remember a number of years ago, maybe 10 years ago, there were issues of mental health issues, inmates within corrections, and Patrick Flood, who was with the Agency of Human Services at that time, put together an intra-agency group to really really address an inmate with mental health issues, to work through the system within the Agency of Human Services. The thinking is, and was back then, was the inmate was most likely involved with other departments within the Agency of Human Services for services. And let's coordinate this so that the proper care and services are provided to the inmate, so it doesn't always fall on the Department of Corrections. And that tended to be pretty effective for a few years. And then people moved on to different jobs, and then it got lost and no longer is occurring. So my question is, this Option 1 seems to be pretty similar to what had been put in place previously under different administration, under different secretaries, under different commissioners. So if we adopt option 1, what's the insurance that 2 years down the road, things change with appointments in terms of who is Secretary of the Administration or who is governor? How do we insulate this against those changes that are bound to occur? That's my concern and question, because I support option 1. I think it's a good direction to go in, but how can we ensure it's going to continue regardless of who's at the head?
Chief, if I could weigh in.
Yeah, Jim, please.
Good morning, everybody. I think David Demore can correct me if I'm wrong, but I think, and I'm not trying to interject what I think the intent was, but I think I understand this from being in the meeting on Friday and working with CSG on this project. This is really meant to be an internal recommendation that we start focusing internally on figuring out processes. And the best way to put it is that the issues that DOC faces with the challenged population that we now supervise, this is not just a DOC issue, it's an AHS issue. And Secretary Smith's been pretty clear on this. And so what this recommendation, as I took it, meant, is that we start figuring out internally inside AHS, for the lack of a better term, make it simplistic, get our act together before we start bringing other people into the conversation. What I always worry about in these processes is that we overprescribe to corrections what needs to be done, and all we end up doing is reacting to the prescription that's been given to us. And it takes out the creativity of my staff to figure out processes moving forward that will be institutionalized inside the department. And in order for us to move forward on what the wishes of reinvestment is, we have to be able to marshal the resources to better support this complicated population. And that's all I thought we were talking about when we processed these recommendations with CSG. So if I was wrong on that, I'd be willing to listen if I misunderstood this.
No, Commissioner, what you just stated, excuse me, what you just stated is accurate. We were looking to have the various agencies in AHS work together more effectively than they currently do, since almost every, not all, but almost every service that somebody may need comes from one of the various departments in AHS. So we were really looking to improve that coordination and communication and overall planning, so that when Joe needs something, there's a system that works in terms of responding. The idea was not to develop something that was necessarily individual case planning, but a systems issue of how AHS responds to all of these and how all the different agencies have a way to access relevant information and a way to be accessed by DOC when DOC has clients that need such services.
Okay, then Commissioner Baker, do we take your comments as a negative voice on this one?
I wouldn't say it's a negative voice to the recommendations there. It would be a negative voice to my colleague, Mac Valario, that we start bringing other folks into this conversation until we get ourselves organized inside AHS to better support this difficult population. There's a commitment inside AHS to do it. That's my point, Chief.
You're speaking against the friendly amendment, which was not accepted in the first place by the mover. So thank you for that, Commissioner. Representative Emmons, do we take your comments as an opposition to this?
No, I'm not opposed to it. My concern is there's a commitment now with the folks who are there. What happens when those folks are no longer there? How can we ensure that this collaboration continues?
Do you see language in the option that suggests otherwise? suggest it shall not continue, it may not continue?
I think we need more, I think we should have language that it continues regardless of any changes that occur in leadership within the agency or on the state level. That's just my concern. I don't want this to get lost 2 years down the road.
So you'd like language added to the first paragraph, if you will, that says this will continue regardless? I'm not sure you can do that, can you?
That's right. So Senator Sears has his hand up.
Yeah, Senator. Senator Sears.
Senator, you're muted.
Yeah, thank you. I'm going to suggest that the legislature can, I plan to go over this report and introduce legislation that would encompass this, and I don't think there's anything wrong with us memorializing this in language requiring memorandums of understanding or whatever we end up doing. So that I agree with Representative on the issue of the Defender General. I immediately think, well, maybe if you're going to include the Defender General, then you'd need to include the state's attorneys, every other aspect of it. I think one of the things I would do in legislation is require some consultation with other players, including the victims community, etc., in working on all of these issues, because they do come into that. And hopefully those commissioners and the parole board working together would consult with all the relevant parties to the criminal justice system.
So, Senator, are you speaking in support of the option as?
I'm actually speaking in support of the original motion to put the language in. What I'm suggesting is that the legislature do something. I'm agreeing with Representative Edmonds that the legislature should put something into statute requiring this as we meet in well, it is January, as we go on, but also we could add to that language something about consultation with others within the criminal justice system, including the courts. I mean, I think we don't operate in a vacuum. We all know that. So we do have to work together, but this is really getting a team, as I see it, an approach for a team to work together. I've been complaining about the problem that corrections faces with mental health cases for decades, and we still haven't gotten as far as we should on solving that problem. That's the biggest challenges for a corrections officer to try to deal with folks that they're not really appropriately dealing with. It should be in a mental health setting, and yet they end up in corrections. I'm supportive of the original motion.
Thank you. Anyone else have a comment or a question or a point they want to make about this, the language here before we call the motion for a vote? I don't hear anything. I don't. Yeah.
Oh, Chief, I just wanted to I just wanted to make sure before you call a motion for a vote, everyone on the working group pretty much spoke to CSG this past week. And I just wanted to, I know that some folks feel less comfortable voting. I just kind of wanted to acknowledge that. And it sounds to me, Chief, that it sounds like you're asking the procedure that you're using right now is a motion and a second. And then if anyone objects, that the vote would be actually the kind of on the negative rather than on the positive. But I just wanted to see if I'm following that correctly and create space if folks don't feel comfortable voting. Yeah.
Well, is there opposition to adopting the language? We can do it this way. Is there opposition to adopting the option number 1 as it's currently written, understanding what Senator Sears has said about the future of it once it goes out in the report? Any opposition? Okay, hearing none, then that one is approved for inclusion in the report. Shall we move?
I think you had one voice of opposition.
I didn't hear it.
It was Matt Valerio.
And I'd like it, and I just want to make a note of explaining why. The Defender General's Prisoners' Rights Office is the only organization in the state that is specifically designated to address the mental health and substance abuse needs of the people within the criminal justice system who are under the custody of the Commissioner of Corrections. And I'm voting against it because it's left off the group that would coordinate that.
Okay, I'm going to move to option number 2 now. Option 2 is relatively short, and according to the agenda, we really only have 10 or 20 minutes. So I don't know that we're going to get through all these, but let's keep going. Option 2 is a requirement. It would be to recommend that DOC use a validated mental health screening tool for people sentenced to probation for misdemeanor offenses. It is a recommendation. It is a recommendation. It's not a requirement. So I would revise my prior comments that way. Anyway, anyone want to speak to this in the form of suggesting a motion to adopt it as it's for?
Chief, just to weigh in from corrections, we have no opposition to this. In fact, we think we believe that people coming directly from court into probation is a place where people start to get trapped in the system, and many times there's underlying mental health and substance abuse issues. So we have no opposition. It ties into the last recommendation around the idea we brought forward on embedding mental health clinicians.
Thanks very much, Commissioner. I'll take that as a motion. Is there a second?
I'll second it.
Okay, any opposition to adopting this as a recommendation that would go into the report? Okay, then we'll move to option 3. This is to recommend the legislature require DOC to develop a brief report that will be provided to judges before sentencing to inform condition setting for all people being sentenced to probation for felony offenses. The report should include risk and need assessment results, mental health and substance use screening results, and criminal history. As I understand it, from talking to David about this before and also hearing his comments this morning, this is not intended to be the equivalent at all of a PSI. As a matter of fact, I recall him saying this endeavor, this undertaking should take no more than, I think he said 30 minutes. He might have even said 20 minutes to accomplish something that would be distinctly different from the pre-sentence investigation reports that we see, the judges see, which are quite lengthy, quite involved, very, very involved, and very, very detailed. So this is something less than that. And anyone want to speak to this?
Judge, again, I don't want to take all the airtime here, Chief, but from corrections standpoint, we support the concept. I know David has stated 20 to 30 minutes, but what we would urge is that we look at it from a standpoint of doing demonstration sites around the state to see if in fact it is helpful, instead of mandating this for all 11 offices, because 20, 30 minutes seems like a small amount of time, but we know the number of cases that go through court, and you multiply that out, it does become a resource issue.
Okay, Jim, can I take that as a motion?
You can, Chief.
I can put you on the spot. How about a second?
Chief, this is Judge Grierson. I surveyed the trial judges, and on one hand, they're certainly supportive of having this kind of information, but at the same time, they recognize the burden it may impose on Department of Corrections to provide this information. And I think David touched on the issues that it comes into play, and that is the timeliness of these reports. In other words, sometimes plea changes are set on relatively short notice, and I think as Commissioner Baker has indicated if we tried it out in some areas to see what it really involves would probably be the best approach. I think it could be helpful, but if we don't get them in a timely fashion, it's not going to help the process.
Is that a second?
I guess we could call that a second.
All right, thanks. Any more discussion about it? It's a recommendation, remember.
Chief, technically, I'm not sure Judge Gerson can second, so can't. I'm happy to be the second.
All right, that's fine. Thank you.
I yield to the court administrator, as I often do.
Any more discussion? Any opposition to adopting it as a recommendation to go into the report? Okay,
Chief.
thank you. Yeah.
Sorry, this is James Pepper, Department of
Yes,
State's Attorney.
Yeah, yeah.
I have a question for David Demora on this. And that question is, would it undermine what we're trying to achieve with this recommendation if the parties or the court were allowed to kind of waive this, or it would be by request only by the court? Kind of like I mean, there's certain instances where PSIs are mandated. I know this isn't a PSI, but there's certain instances where
it's needed, is what you're saying. As
exactly.
Needed. Yeah. David, you want to respond?
I'm sorry, I was trying to think of a subtle way to respond. The reality is that what I saw was inconsistent, and the decisions about when and when not to get information was different depending on the various personalities involved. And I mean that when I say personalities, I mean judge, prosecutor, defense attorney. I mean everybody. So what we were attempting here was to assure a baseline consistency that anytime somebody was before the court, we could be sure, they could be sure that information that could help make sure the best recommendations are made exist. I certainly do understand the concept of maybe piloting it in certain places and starting there. It's the end result that I think is important, which is that information gets done and gets to the court. And as I said in my presentation, it may be that there are different ways to figure out how to get there. What I wouldn't want personally, it's up to you to decide, of course, but what I personally wouldn't want is a situation that essentially says, it's a good idea to do this, and then half the system not do it down the road. And it be put back into who asks who asks. So one of the reasons for putting it this way was to sort of put it in that realm of this is something that needs to happen. And yeah, it does have to be figured out. And I very much understand the commissioner's concern about figuring out resources and piloting, but I would be concerned about writing it in a way where down the street, if I'm in court over here, it happens, and if I'm in court over here, it doesn't happen, and that the reasons for that are strictly the various personalities that are involved.
James, have you got any follow-up?
No, thank you. That was very helpful. Yep.
Gary, I'm trying to find the chat. There's a question, I think, Gary Marvell, in this recommendation, is there an expectation that the court will be mandated to incorporate the report into the conditions of probation? David?
If I understand the question, the judge still has the final authority to make whatever decisions he or stipulations he or she thinks should be made, and nobody can or should be trying to take that away. The idea here is to make sure that there's as much relevant and related to needs of that individual information is available as a court makes a decision. And we would hope that the court would take the results of this information into their thinking as they put out stipulations, et cetera. But it is certainly ultimately up to that trier of fact, if you will, to make that decision. And I certainly don't feel like I could say that there has to be something where they're then required to specifically do A because of what the risk assessment says or what the mental health assessment says. I would argue that when stipulations are made based on that information, they are more defensible for all parties involved.
Thank you, David. I'll give a second to see if Gary has a follow-up. How about other comments on this one? No, he says no.
Chief, can we just clarify, is the current motion on the table to adopt policy option 3 as is or to adopt it as a pilot? I think I'm personally not clear on which direction we're heading here.
It's my understanding it's as is, but
yeah.
Someone has a different impression. Pat?
No, that was the motion I seconded.
Okay, thank you. Thanks for clarifying.
Okay, any other comments? How about opposition to adopting this as a recommendation? Is there opposition? Just indicate yes or no. Okay, then option 3 is approved for inclusion as a recommendation in the report, and we'll go to 4, which is noted to be strategic. It's to recommend that DOC explore hiring licensed clinicians to be placed in local supervision. Did we already do this one? Now I'm lost. Huh? We didn't do it, right? Okay. To be placed in local supervision offices to administer mental health and substance use screenings and assessments, as well as liaise with community-based treatment providers. Comments on this one? It's a recommendation that would go into the report. Again, CSG laid out at the beginning that their position is that they'd like to see all 4 options in the report, but it doesn't, the working group is not required to come to that conclusion. But right now we have agreed to include options 1, 2, and 3 as recommendations again in the report. How about number 4?
I move we support option 4 and include it in the report.
Okay, thank you, Representative. Is somebody second that?
I'll second it.
All right, thank you. Is that Matt? Yeah, okay.
Yes.
Thank you, Matt. Thank you. How about discussion? Any discussion or opposition to including option 4 as a recommendation?
Yeah, I'd like to, I'm just curious, Chief, if DOC, I believe, has a plan to do this. Would that be available to us at some point in the near future, Jim?
Senator, I wouldn't.
Commissioner, I'm sorry, Commissioner. That's
okay, Senator. That's why I refer to myself as interim commissioner. Senator, I wouldn't say we have a written plan as of yet. A lot of conversation, both internally and with
somebody needs to mute, please.
Both internally inside corrections and with the administration and inside AHS. And so we're starting the dialogue about what that would look like, because as you know, the complications around if we employ a licensed clinician and the level of supervision that's needed, for example, that presents challenges. So we're just starting to sort out the conversation now. And I think at some point in front of your committee and other committees, we can hash out the details.
Thank you.
Okay, is that opposition to this one, Senator Sears?
Oh, I just wondered if,
You wanted clarification, I understand.
yes.
How about other voices? Anyone opposed to this? Want to speak to it? I'll call for opposition now. Anyone opposed to adopting, approving option 4 as a recommendation to go in the report this week? All right, I think we've now reached a point where we can take a break if that's okay with Sarah and David and Loretta and Madeline. Yes?
Certainly.
Okay, so we'll take 10 minutes, come back a little after 10 o'clock, 10:02. Thank you very much. Thanks for your cooperation on this. Thanks.